Patent trolls. No, they don't live under bridges, but they do love to block innovation. These so-called non-practicing entities, or NPEs, are companies that don't actually make or sell products. Instead, they acquire patents, sometimes obscure ones, and use them as legal weapons to sue businesses for alleged infringement. Just this Tuesday, a case by Patent Armory against Creality was voluntarily dismissed. In April, Patent Armory had sued Creality for allegedly infringing their patent related to 3D scanning. The alleged infringing product was Creality's CR-Scan Ferret 3D scanner, seen here. Now let's dive into the story of Patent Armory, a notable NPE, and its legal battles with companies like Creality, Scantech, and Artec over 3D scanning technology. Patent trolls, or NPEs, operate in a murky corner of intellectual property law. Instead of developing products or technology themselves, they profit by enforcing patents, often filing lawsuits against companies that are actually innovating. These lawsuits are frequently filed in plaintiff-friendly jurisdictions, like Delaware or Texas, to maximize their chances of success, or at least a hefty settlement. One such company, aptly named Patent Armory, has made headlines for its aggressive litigation strategy. At the heart of their lawsuits is a patent titled Wireless Methods and Systems for Three-Dimensional Non-Contact Shape Sensing, granted back in 2007. This patent has become their weapon of choice in a series of legal battles. Patent Armory most recently wielded this patent in a lawsuit against Creality, a prominent 3D printing company, claiming infringement by Creality's CR-Scan Ferret 3D scanner. The lawsuit was filed in Texas on April 4th, 2024. No surprise there, given Texas's reputation as a hotspot for IP litigation. But just last month, a notice of settlement was filed, and as of just 2 days ago, the case was voluntarily dismissed. Last year, they sued Scantech over its iReal 2 eColor 3D scanner, and also went after Artec for their Leo scanner. Patent Armory had filed suit against 11 companies in total for this patent. Interestingly, Artec has been on both sides of the battlefield. Back in 2022, Artec sued Creality, accusing them of infringing a different patent related to 3D shape measurement, granted in 2010, 3 years after Patent Armory's patent. Of the 11 companies Patent Armory sued last year for the same patent, all the cases were voluntarily dismissed, except for Artec, which was just recently dropped. While some dismissals happened quickly, most occurred in August of this year. Notably, Creality's case is the only one mentioning a settlement, leaving us to speculate on what resolved the others. Why should we care about these lawsuits? Patent trolling stifles innovation. Companies like Creality and Scantech, which are pushing the boundaries of 3D scanning technology, have to divert resources from R&D to legal defense. It's a lose-lose situation for everyone, except the trolls, but all is not lost. Organizations like Unified Patents are fighting back. Unified runs a project called Patrol, which aims to take the fight to patent trolls by uncovering prior art, evidence that a patent claim isn't actually new or innovative. They've even issued bounties for prior art against Patent Armory, rallying the community to protect innovation. While it's a long game, initiatives like this offer a glimmer of hope for companies targeted by NPEs. Patent trolling isn't just a tech industry problem, it's a global one. From software to biotechnology, no sector is immune. And as the case of Patent Armory shows, it's a tangled web of legal claims, counterclaims, and settlements, with real consequences for innovation and consumers. So what can we do? Supporting reforms to patent law, encouraging transparency in litigation, and backing organizations like Unified Patents are good starting points. Because if we don't stand up to patent trolls, the real cost will be innovation itself. Like, comment, and subscribe for more stories on 3D printing and the law.